I want to run a scenario by you. It's a bit visceral, so stick with me for a second. Imagine walking into the most critical meeting of your career. You've got investors on one side, your biggest competitors on the other, maybe even the tax man on the corner. You feel totally confident. Your strategy is perfect. But then you look down and you realize you're completely naked.
That is the classic anxiety dream, isn't it? I think we've all had a version of that at some point.
We have. But here's the hot for today's deep dive.
Hmm.
For the vast majority of South African entrepreneurs, that nightmare is, well, it's their financial reality. They just don't know it yet.
They're walking around what our sources call commercially naked.
Exactly. It's a vivid image.
It is, and unfortunately a very accurate one.
It is. And today, we're going to fix that. We are going on a mission to build what's described in our research as an asset protection fortress. We've got a heavy-hitting stack of materials. We're diving into the methodology of Lemke Sturman, a specialist trust consultant, and layering that with a really intense analysis of a document called Vital Directives.
And I think the biggest misconception we need to just shatter right up front is who this is actually for.
Yes, exactly. Most people hear trusts and asset protection, and they immediately think of, the billionaires, the Ruperts, the Oppenheimers.
Right. If you don't have a private jet, you don't need a trust.
That's the thinking. But it's a trap. If you're a business owner turning over, say, anywhere between 1 and 50 million rand, you're actually in what our source calls the red zone.
You have enough assets to be a target, but usually not enough structure in place to survive a real hit.
You're building a legacy, but you've left the back door completely unlocked.
So let's talk about that unlocked door. Lemke Sturman's material points to a specific cardinal sin that most of us commit without even thinking.
The mixing of liabilities.
It comes down to this idea of the sieve versus the wall. In a perfect world, there's a concrete wall between your personal life, your home, your savings, and your business risk.
But for most entrepreneurs, it's a sieve.
It is. They sign personal sureties for business loans. They trade in their own name. The valuable assets are kept inside the company that carries all the risk.
Which means if the business catches a cold, your personal life gets pneumonia.
It's worse than that. If the business gets sued, faces a SARS audit, or is liquidated, creditors can reach right through that sieve.
They can take the house.
The house, the car, the personal savings, everything, because you haven't separated the ownership from the risk.
That is a terrifying thought. So this fortress concept is the antidote. Break down the architecture for us. Lemke outlines a triad structure.
It's a separation of powers, really. You have 3 distinct entities. First, the trust. Second, the company. And third, you, the individual.
And each one has a very specific job to do in this fortress.
Exactly. Think of the trust as the vault. It owns the assets, the shares, the property, the long-term wealth. It doesn't trade. It doesn't sign risky contracts. It just sits there and stays safe.
The vault holds the treasure.
Then you have the company. The company is the soldier. It goes out onto the battlefield. It signs contracts, hires staff. It takes all the risk.
And if the soldier gets shot?
The vault is untouched. The soldier might go down, but the wealth, the family's legacy remains secure. And that brings us to the third player, you.
The commander.
Your role is commander. You control everything, but here's the key. You don't own anything. Personally.
Control everything, own nothing.
It's the Rockefeller principle. If
Yeah.
you own nothing, a creditor who sues you personally has nothing to take. They can't break into the trust because those assets don't belong to you.
They belong to the trust.
Right. And that distinction is it's crucial.
But I want to push back on this a little bit, because when people hear trust in South Africa, they immediately think tax complication, or that SARS is going to come down hard on them. There's a real fear there.
And it's a valid fear because the laws have changed. But if you look at the math in the source material, a trust is actually a massive efficiency tool if you play by the rules. You have to look at the 2 silent killers of generational wealth in South Africa.
Estate duty and capital gains tax.
Grim, but very expensive. When you die, if all your assets are in your personal name, the government treats it like you sold everything you own the second before you died.
Wow.
So that triggers capital gains tax on all the growth. Then, on what's left, they charge estate duty. It can be up to 25%.
So you could lose a third, maybe even more, of your net worth just by dying.
Easily. And that liquidity crunch forces families to sell the business or the farm just to pay the tax bill. But, and this is why the fortress works, a trust doesn't die.
It's legally immortal.
In a sense, yes. If the assets are in the trust, your death is not a disposal event for those assets. They just stay there. So no estate duty, no capital gains
The
trigger.
wealth just compounds uninterrupted.
Exactly. It freezes the risk.
Okay, that explains the long-term why. But let's talk about the tax on the income while you're alive. I saw a number in Lumka's notes that made my eyes water. 45%.
Yes. That's the flat tax rate for income retained in a trust. It's punitive. It's the highest marginal rate. If a trust makes R1 million profit and just keeps it, SARS takes nearly half.
So why would you do that? It sounds like putting money in a bucket with a giant hole in the bottom.
Because of a mechanism called the conduit principle. This is the magic wand in South African trust law. The trust doesn't have to pay that tax.
Okay.
It can distribute the profit to the beneficiaries.
It flows through.
Like a conduit. And here's the trick. The tax liability lands in the hands of the beneficiary at their personal tax rate.
Okay, so let's play that out. If I have a trust and it makes money, I can distribute that to, say, my university-aged kid who has very little other income.
Exactly. Their tax rate might be 18% or even 0. Or you distribute it to a spouse who earns less than you. You're using the trust to average out the tax burden across the whole family unit.
That's incredibly sophisticated. So you have options. Pay the 45% for ultimate safety or distribute it for efficiency.
Precisely. Flexibility is the ultimate form of wealth protection.
Okay, so we've built the fortress for the money.
Right.
The trust is the vault, the company's the soldier. But reading through the vital directive source, I realized we have this glaring vulnerability in the system,
The human element.
the human element.
Yeah.
We've protected the assets from lawsuits and tax.
Yeah.
But what happens if the commander, the business owner, suddenly goes offline? And I don't mean on vacation. I mean medically.
This is what we call the bus factor. In
Bam.
project management, you ask, how many people need to get hit by a bus for this project to fail? For most SMEs, the answer is 1.
And the source makes a really disturbing point. We all kind of plan for death. We have wills. But almost nobody plans for what it calls the gray zone.
And the gray zone is actually worse than death for a business. If you die, your executor steps in. There's a legal process. It's slow, but it's clear.
Right.
But if you have a stroke or a traumatic brain injury, you're still there. You're the director. But you can't speak. You can't sign.
What happens to the bank accounts?
Frozen. Almost immediately. The banks hear about capacity issues and they lock it all down to protect themselves.
So payroll doesn't happen. Suppliers don't get paid.
And the staff start updating their CVs because they see a rudderless ship. The business can bleed to death in months.
There's a distinction in the documents I think is critical. Living well versus healthcare directive. People use them interchangeably, but they aren't the same thing, are they?
No, not at all. Totally different tools. A living will is for the doctors. It says, if I'm in a vegetative state, turn off the machine. It's an end-of-life document.
A medical instruction.
Exactly. A healthcare directive or a proxy is about authority. It designates a specific person to speak for you when you can't. And when you pair that with a business continuity plan, it lets someone step into your shoes legally and immediately.
The case studies and the research really drive this home. The Helen Crawford case was just heartbreaking, so preventable.
Helen Crawford is a perfect example of the limbo problem. She ran a tech services company, sole owner. She gets into a car accident, severe brain injury. She wakes up, but she's cognitively impaired, confused.
So she's not in a coma, she's walking around.
And that's the problem. Her husband, Richard, tries to step in, but the bank says, who are you? Helen is the signatory. The lawyers say, well, she's awake, so we need her consent, but she can't give informed consent.
It's a catch-22.
A bureaucratic nightmare. They spent 6 months arguing over her legal capacity. In that time, her biggest client canceled their contract and her operations manager quit.
Wow.
By the time Richard got a court order to manage her affairs, which is a curatorship, a very expensive and public process, the business was worth half of what it was.
And all that could have been solved with a piece of paper.
A carefully drafted piece of paper, yes. If she had a directive with activation criteria, say, if 2 independent specialists certify I'm incapacitated, my husband gets power of attorney, there's no argument. You just flip the switch.
It's like a generator kicking in when the power fails.
Right.
You don't want to be wiring the generator while the lights are already out.
That is a fantastic analogy. You have to install it while the sun is shining.
Then there was the other case, the Thompson case. That touched on a different nerve, didn't it? Family dynamics.
Ah, David Thompson. This highlights the messy side of blended families. Successful engineering consultancy. He has a stroke. He can't communicate.
And the cast of characters is a blended family.
Yes. A current wife and adult children from a previous marriage. And they did not get along.
I can see where this is going.
Without a directive saying who is in charge, Both sides claim they knew what David would have wanted. The wife wanted to sell the business for medical care. The kids wanted to keep it running to protect their inheritance.
So they go to war.
To court. And while they fought, the consultancy stalled. Clients left. The business was eventually sold for cents on the rand. The legacy was destroyed not by the stroke, but by the conflict.
This brings us back to Lumka Sturman's approach. It's not just about the money or just about the health. It's the combination.
That's why she calls it shielding an empire. You need the trust to hold the assets, but you need the directives, the human software, to make sure the system works when things go wrong.
Okay, let's get into the mechanics of the trust itself again, specifically for South Africa. Because there's a trap here for the DIY crowd, the control myth.
Yes, entrepreneurs are control freaks. It's why we start businesses. But with a trust, you have to let go to gain protection. The trust has a founder, trustees, and beneficiaries.
And usually in a family business, the founder puts themselves in all three roles.
Which you can do. However, the master of the high court is watching. If you treat the trust like your personal wallet buying groceries, paying for holidays, the courts can declare it a sham.
A sham trust. That sounds like game over.
It is. They pierce the veil. They say, this isn't a trust. This is just you. And suddenly all that creditor protection vanishes.
So how do we prove it's not a sham?
The independent trustee. This is non-negotiable in modern South African trust law. You must have at least one trustee who is not a beneficiary and not related to you. A professional.
And their job is to be the adult in the room.
Their job is to say no, or at least let's follow procedure. They ensure the meetings are held, the resolutions are signed. They're the insurance policy that keeps the trust valid.
So if you're listening and thinking, I'll just download a trust deed template off Google, stop.
Please stop. A template from 2015 is likely already outdated. If you mess up the registration with the master, you don't have a fortress, you have a pile of paper.
This is where Lumka Sturman's role as an educator comes in. The source lists her values as integrity, education, and excellence. It doesn't feel like a sales pitch, it feels like a curriculum.
And that matters. She offers a foundation audit for new owners. It's a reality check. Here is where you are exposed.
And the asset protection blueprint.
Which is the roadmap, but I think the most valuable service is the Fortress Review.
The annual checkup.
Think about it. In 10 years, you might get divorced, have more kids, emigrate. Tax laws will definitely change. If your trust deed sits in a drawer gathering dust, it becomes a liability.
It's maintenance. You wouldn't drive a car for 10 years without a service.
Exactly. Your personal legacy deserves the same attention.
Her motivation really struck me too. Her site says she believes everyone deserves financial security and peace of mind. It all comes down to sleep, doesn't it?
It does. The sleep test. Can you sleep knowing that if a massive lawsuit hits your company, your children's home is safe? Can you sleep knowing that if you can't speak next week, your business won't collapse? That's what you're buying. Not legal documents. The ability to help.
So let's synthesize this. We've covered a lot of ground.
We have.
We have the trust, which shields the money from the external world, creditors, taxes, predators, that's the hardware.
Right.
And we have the directives, which shield the business from internal chaos, incapacity, family fighting. That's the software.
And you combine them, you have a legacy, a system that survives you. And that is the definition of a legacy. What happens when you're not in the room?
I want to leave our listener with a challenge, a stress test for their current reality.
Go for it.
I want you to imagine that starting tomorrow morning, you are unable to speak, email, or text for 6 full months. You are alive, but silent.
6 months. That's a lifetime in business.
Does your business survive?
Yeah.
More importantly, does your family know what to do? Or are they fighting a war on 2 fronts? One against the doctors and another against the banks to save your assets.
If that question makes your stomach tighten, you know you have work to do. You're the naked entrepreneur we talked about at the start.
So let's get you dressed. The call to action is clear. This isn't a DIY project. You need a guide.
You do, and Lumka Sturman is positioned exactly for this.
You can go to www.lumkasturman.com. She has an asset protection waitlist you can join.
And look for the estate planning toolkit on the site. It's a great way to just learn the terminology before you dive deep.
Or better yet, just book the consultation. Video or in person. Stop guessing. The cost of doing nothing, as we saw with the Thompson family, is infinitely higher than the cost of setting it up right.
The cost of doing nothing is your legacy.
A legacy isn't just what you build, it's how you protect it. Thanks for diving deep with us today.
Bye-bye.